Good evening. Good evening, everyone. Wow, that was pretty good for a full house. Well done. My name is Jamie Boskett. I have the privilege of serving as president and CEO here at the Virginia Museum of History and Culture, and I'm honored to be the first to officially welcome you to tonight's program. Thank you so much for joining us. This evening, we are so pleased to be co-presenting this timely discussion with our friends at the John Marshall Center for Constitutional History and Civics. I'm also pleased to serve on that board of the John Marshall Center, but that's not the most important reason why collaboration between these two organizations is such a natural. We have shared values and a shared history. After all, Chief Justice John Marshall, as many of you know, was the very first president of this historical society. Civics and history are fundamentally linked and alike essential for an engaged citizenry. So we're thrilled to present this program together. I just have to take a sidebar because just the other day, I was looking at the civics study presented annually by the Annenberg Public Policy Center at the University of Pennsylvania, and thinking about it in the context of having robust conversations about being engaged in our government. They do this every year on Constitution Day, this national survey, and it wasn't pretty, to say the least. Less than half, 47% of US adults could name all three branches of government. Only 1 in 4 respondents could name a single branch. Asked to name the rights protected by the First Amendment, people were at a loss. Less than 1 in 4, 24%, could name freedom of religion. This is a time for educational organizations like the VMHC, like the John Marshall Center, to keep doing everything we can to inform and engage Virginians, Americans, and everyone who will listen who is fortunate enough to be in this wonderful country. So we're going to keep up all this great work, and we can do that together, and we're thrilled to do it, and thrilled to put on such an engaging program that hits on these very topics tonight. So thank you to all of the members of the Virginia Museum of History and Culture, also to the members of the John Marshall Center for empowering us to do this collective good work. It's now my pleasure to make introductions for tonight's program, to invite my fellow trustee of the John Marshall Center forward, Paul Harris, to introduce our speakers. Thank you so much.
Good evening. Good evening. I have the distinct privilege this evening of introducing our distinguished moderator and our distinguished panelists, two of whom are former colleagues from the Department of Justice and a new friend in Don Verrilli. Delighted to have all of them with us this evening. I'll begin by introducing our distinguished moderator. Professor Allison Orr Larson is a professor of law and director of the William and Mary Institute of the Bill of Rights Law. Since joining the William and Mary Law faculty in 2010, Professor Larson has received many awards honoring her teaching and scholarship, including the statewide Outstanding Faculty Award in the Rising Star category. This is Virginia's highest faculty honor. She is a scholar of constitutional law and legal institutions with a focus on how information dynamics affect both. Her work on fact-finding at the Supreme Court has been featured multiple times in the New York Times, the Washington Post, and the Wall Street Journal. It was also the subject of her testimony before the Senate Judiciary Committee in April 2021. Professor Larson has published in the nation's top law reviews, and her work has been cited by 4 different U.S. courts of appeals. She appeared with Stephen Colbert as a guest on the Colbert Report to discuss her scholarship. She also has a little fun. Her scholarship on Supreme Court amicus briefs, a subject on which she has also testified before the Presidential Commission on Supreme Court Reform. Professor Larson earned her Bachelor of Arts degree from William and Mary and her law degree from the University of Virginia, where she graduated first in her class. After law school, Professor Larson clerked for Judge J. Harvey Wilkinson of the U.S. Court of Appeals for the Fourth Circuit and for Justice David Souter of the United States Supreme Court. Professor Larson.
Thank you.
I will introduce the panelists in the order in which they served as Solicitor General. Paul D. Clement was the 43rd Solicitor General of the United States. Mr. Clement is a partner at the Clement and Murphy Law Firm and distinguished lecturer in law at the Georgetown University Law Center. Mr. Clement served as Solicitor General from June 2005 until June 2008. Before his confirmation as Solicitor General, Mr. Clement served as acting Solicitor General for nearly a year and as Principal Deputy Solicitor General for over 3 years. He has argued over 100 cases before the United States Supreme Court. Mr. Clement's practice areas focus on appellate matters, constitutional litigation, and strategic counseling. He represents a broad array of clients in the Supreme Court and in federal and state appellate courts. Last year, he successfully argued Supreme Court cases involving significant issues of energy regulation, statutory interpretation, state sovereign immunity, and Article III standing, and successfully argued a trademark appeal in the Fourth Circuit and a constitutional appeal before the en banc 11th Circuit. Mr. Clement earned his Bachelor of Science degree summa cum laude from Georgetown University School of Foreign Service, Master of Philosophy degree from Darwin College at Cambridge, and Juris Doctor magna cum laude from Harvard Law School, where he was Supreme Court editor of the Harvard Law Review. Following law school, Mr. Clement clerked for Judge Lawrence H. Silberman of the U.S. Court of Appeals for the D.C. Circuit and for Justice Antonin Scalia of the United States Supreme Court. After his clerkships, he went on to serve as chief counsel of the U.S. Senate Subcommittee on the Constitution, Federalism, and Property Rights. Please help me welcome Mr. Clement. Donald B. Verrilli Jr. was the 46th Solicitor General of the United States. Mr. Verrilli is a partner in the law firm Munger, Tolles & Olson and the founder of its Washington, D.C. office. Mr. Verrilli is also a lecturer in law at Columbia Law School, where he teaches classes on the First Amendment and the Supreme Court. Previously, he taught First Amendment law for many years at the Georgetown University Law Center. Mr. Verrilli is one of the nation's premier Supreme Court and appellate advocates. He served as Solicitor General of the United States from June 2011 to June 2016. Before serving as Solicitor General, Mr. Verrilli served as Deputy White House Counsel and previously as Associate Deputy Attorney General in the United States Department of Justice. In those positions, he counseled President Obama, cabinet secretaries, and other senior government officials on a wide range of legal issues involving national security, economic regulation, domestic policy, and the scope of executive and administrative authority. Mr. Verrilli earned his Bachelor of Arts degree, cum laude, from Yale University, and his Juris Doctor degree with honors from Columbia Law School, where he was editor-in-chief of the Columbia Law Review. Please help me welcome Mr. Verrilli. And last, but certainly not least, Noel J. Francisco was the 47th Solicitor General of the United States. Mr. Francisco is the partner in charge of the Washington office of the Jones Day law firm. Mr. Francisco served as Solicitor General from 2017 to 2020. He represents clients in a broad array of civil and criminal litigation, challenges to federal and state laws and regulations, and government investigations and enforcement actions. The matters he handles often have significant public policy implications, including in the areas of global climate change, opioids, asbestos, tobacco, firearms, healthcare, administrative law, free speech, religious liberty, and separation of powers. He earned his Bachelor of Arts degree in economics with honors from the University of Chicago and his Juris Doctor with high honors also from the University of Chicago. After law school, Mr. Francisco served as a law clerk to Justice Antonin Scalia of the United States Supreme Court. And before that, he served as a law clerk to Judge J. Michael Ludig on the U.S. Court of Appeals for the Fourth Circuit. Later, Mr. Francisco served as Deputy Assistant Attorney General in the Office of Legal Counsel at the U.S. Department of Justice, and prior to that, as Associate Counsel to the President of the United States. Please help me welcome Mr. Francisco. Allie, over to you.
All right. Thank you so much, Paul. Well, y'all are in for a treat tonight. Have you ever seen when they do a Hollywood promo and they say all-star cast? This is an all-star cast of lawyers. So you heard from Paul that these are 3 former Solicitor Generals of the United States. So I thought I'd give you a little bit of context for why that's such a big deal and what that means. The Office of the Solicitor General supervises and conducts litigation on behalf of the United States in front of the U.S. Supreme Court. And they are very busy because approximately 2/3 of the cases that the Supreme Court hears on the merits involve the United States. So the SG, that's what we say, the SG, the Solicitor General, has been called the 10th Justice. And the reason for that is because that office has developed over time a reputation of fairness and reliability. I know when I clerked there, we always picked up the gray brief first. That's the SG brief. And so I think it's really important, and what we're going to do tonight is talk a little bit about the history of that office, and here's some war stories along the way, I hope. So let's just start off with some basics. What's it like to prepare a Supreme Court oral argument today? And then maybe we can draw some comparisons to earlier years. I'm guessing it's kind of hard. What's the hardest part about it?
It's hard all the way around, but you know what the hardest part about it is, at least for me, there are cases when you're Solicitor General that you have to argue where you know you're going to lose. You got to go in there and represent the position of the United States, but you know you're going to lose, and you might well get your head beaten in, but you can't go up to the lectern thinking that way. So actually getting yourself in the position where by the time you stand up there to argue a case, you actually believe that this complete dead loser of a case that you have to argue you're right about. That's always, for me, was probably the most challenging part of it, is trying to deal with that.
Oh. Do y'all agree?
That is certainly a big part of it. The first thing I'd say is that often people refer to the Solicitor General as the 10th Justice. I have never heard a Supreme Court justice refer to the Solicitor General as the 10th Justice. But what Don said is exactly right. One of the arts of being the Solicitor General is that sometimes you got a losing case and your position is just locked in because you're representing the government. But there are good ways to lose and bad ways to lose. And sometimes, but I'm only half joking. Sometimes you're trying to guide the court to a way to rule against you that's going to do the least amount of damage to the government's institutional interests. And actually, the very first case I ever argued in the Supreme Court was against Don. And it was a big separation of powers case where it was pretty clear that the court was leaning in favor of my client on the bottom line position. It had to do with the president's recess appointment authority. But there were 2 ways that I could win that case. One was a very broad rule that would have called into question a lot of recess appointments. And the other was a very narrow rule where my client would have won, but nonetheless, it wouldn't have such a broad impact on the government's functioning going forward. And I always use that as an example that I point to about a Solicitor General standing up and really doing a powerful job of pushing the court towards ruling against him, but in a way that was the best way for the government to lose in that case. And Don was just brilliant when he argued, when he argued that case.
Basically by saying, pay no attention to that issue. That's fine. You know, if you want to rule against me on that, I'm okay with that. You know, I didn't quite say it in those words, but and we got precisely 0 votes on that issue. So.
And I'll just add, you know, first on the 10th justice thing, Noel's right. The 9 real justices don't talk about the SG that way. One of our illustrious predecessors, the late Drew Days, talked about the SG as the 36th law clerk to the justices. And I think that sort of captures the relationship and the power dynamic a little bit more accurately. But there is that kind of close relationship. And it's born, you know, partially of the fact that, you know, it is a coordinate branch of government that's being represented by the Solicitor General. But it's also more practically born of the fact that you are a repeat player up there. As you alluded to, the SGs in like 2/3 of the court's cases, but you also have this kind of, you know, institutional interest, and you're going to be back up there maybe on the same issue. I mean, you know, during my time in the office, I probably argued 4 or 5 cases involving sort of issues arising out of the war on terror, but I also argued 4 or 5-ish cases involving challenges to the campaign finance laws. And it's just a, you know, in that context, when you're going to be back up there on similar issues in a couple of months, you have a different relationship with the court than you do if you're just up there for a private company as their lawyer. And this really gets to what both Don and Noel were getting at, which is, you know, preparing an argument for any client is difficult. I mean, you know, next month I'm going to be arguing a case about, you know, patent law. That's really difficult. So it's always a daunting task to get ready to present argument to the Supreme Court. But in some ways, it's an even more daunting task for the lawyers in the SG's office, because I think they are charged with this kind of knowledge of the broader institutional interests and priorities of the executive branch and the government. And that's why this idea of sort of losing a case the right way, that doesn't really translate to private practice very well. I mean, in private practice, if you lose, you lose. Yeah. And telling a client in private practice, well, we actually picked the best way to lose this case for you. That does not get you hired for the sequel, okay? But in the government, that's really a thing, because you are going to be up there. And if you lose, you know, like just to take an example and kind of, you know, from the cases I was talking about, if you lose the first case that's a challenge to the campaign finance laws, but you lose it in a way that you can win some subsequent ones, that's a much better result for the government than losing sort of the first one in a way that makes it kind of hopeless going forward. So that really is, you know, an important part of the dynamic, and it is what makes arguing cases in the SG's office, if anything, even a little more challenging.
So when you watch an oral argument today, it's especially with lawyers like we have in front of us, it's conversational if it's done right. Has that always been the case, or has oral argument in front of the court changed? Like, what's like sort of take us on a historical tour. Paul, maybe you can start us off.
Sure. And, you know, I mean, I love, you know, part of the reason I was so happy to come here today is because, you know, if you talk about John Marshall to a Supreme Court advocate or a history buff, and I consider myself sort of both, it's like you want to say yes as quickly as possible. And, you know, one of the things just, you know, in reflecting on this, the dynamic of oral argument from the advocate's perspective is kind of so much different today than it was in the time that John Marshall was the Chief Justice. And, you know, back in those days, the oral arguments would span days in big cases. And you'd have multiple advocates, you know, for one party in the case, and they could, you know, literally spend days arguing in front of the court. You know, based on what I've read, you know, as a result of that, the kind of exchanges with the justices were not kind of what you're used to in kind of the modern court, where things are, on the one hand, much more compressed, but on the other hand, are much more interactive with the justices. And as you say, you know, it can be a conversation, it can be an argument, but it's either way, it's very interactive with the justices, and the time is tight. Things are changing kind of by the day at the Supreme Court. You know, I used to, first, you know, decade or so I practiced there, everything was exactly the same and nothing changed. And in a case, you would 60 minutes for an argument, unlike days back in the Marshall era. 30 minutes aside, if you were appearing on behalf of the United States as an amicus, you would have 10 minutes of argument time, and that's it, on an issue of huge national importance. And that is probably the most difficult thing you can do as an advocate, is to have your 10 minutes to make your whole case. John Roberts, sort of, when he was an advocate and he was in the SG's office, he likened the difference between a 30-minute argument and a 10-minute argument, and the difference between being dropped with a parachute from 30,000 feet and 10,000 feet. Just 10 minutes. There's no margin for error or digressions. It's an incredibly intense sort of experience. Now, it's changing a little bit, and maybe Don and Noel want to sort of talk about that. And then the other thing I will say is, even in the modern era, it's changed quite a bit over the past 40 or 50 years. If you go on oyez.org, and I highly recommend it, and go listen to a big oral argument in a huge controversial case from the 70s. Pick something like Roe v. Wade, or really any case from that era. You will be astonished by kind of how much airtime the lawyers have and how relatively few interjections from the justices there are. And that all changed in about 1986. And maybe I'll lateral to Noel, and he can talk about our old boss.
Yeah, in the great year of 1986 was when Justice Antonin Scalia came onto the court. And it really did change the dynamics of oral argument, because prior to then, you really did have oral argument driven by the lawyers and not the justices. You get an occasional question, but for the most part, the lawyers had an opportunity to make their presentations. Now, Paul's right that today things are changing, but they're changing within a limited band that is very different than what it was like in the times of Chief Justice Marshall. Right now, we're going from maybe what used to be a pretty tight 60-minute argument to, in really big cases where there are lots of parties, 3 or 4 hours, to, in your more ordinary case, probably an hour and a half. Back then, you would have days of argument, and the justices would rarely ask any questions at all. And if you want to see a modern analog of what the court was like back then, you can look at some of the European courts and some of the international courts. I had an opportunity to be part of a DOJ, a Department of Justice team that argued in the International Court of Justice about 20 years ago. And we were there for a week, 8 hours a day, where different lawyers stood up and made speeches for 8 hours a day. Not a single question from any member of the court. And if there were going to be a question, and there wasn't, it was understood that the question would be submitted in writing the day before. And so the following day, we could show up with our prepared response to their question submitted in writing. I suspect that's a lot closer to what the Supreme Court was like when Chief Justice Marshall was presiding over the court, compared to what it is. And when you compare it to that, the changes that we're talking about today seem fairly, they're fairly modest in going from an hour to an hour and a half, a very vigorous argument. But the big sea change, I think, between the Marshall era and today's era really was when Scalia came onto the bench and made it made the hot bench the standard rather than the exception.
Yeah, I clerked on the court 84, 85, so right a couple of years before Justice Scalia arrived, and it was not uncommon then to go for that 30-minute period with maybe 2 or 3 questions. Sometimes there would be no questions even to an advocate. It was quite remarkable, the difference. And it was different in lots of ways too. Sometimes the justices would fall asleep up there because, and that's inconceivable now because there's so much going on, but it is quite different. But I would say I really like the fact that it's loosening up a little bit now, because I had felt when in that sort of strict 60-minute time frame Paul was talking about, you've got all these justices up there who are brilliant people, and they really thought about the cases. And they want to get their questions in. And so it was a little bit like a game show in that, they have to hit a button to activate their microphone to ask questions. So you'd see them hovering over the microphone, hit the button so they could get in. And as an advocate, I felt at least, it made it quite disjointed. Someone's asking about this and somebody else jumps in with something over here. The fact that there's not this strict time limit anymore and the arguments are running somewhat longer, everybody relaxes a little more. Each justice knows that he or she can get the questions answered at some point in the argument, and I know, I like it. I will say I like that. It does tend to go on a little bit too much, I think, but overall I like it.
So we're not doing the multi-day arguments anymore, but do you think there's part of Marshall's legacy that does live on in today's Supreme Court and maybe in, what do you think?
Well, I mean, let me start off with just there's lots of different ways to approach this. I mean, obviously his legacy lives on in, judicial review, and, that's sort of the most obvious way, going all the way back to Marbury. But just to kind of, the anecdote that I like actually even predates John Marshall going on the Supreme Court, and just shows what a kind of iconic figure he is in the law and the continuing legacy he has. So when he was in the House of Representatives as the representative from Richmond, he gave a speech on the House floor on March 7th, 1800, which I think is the most legally significant speech, not politically significant, but legally significant speech ever given on the House floor. And it was in response to the Robbins affair, which President Adams had returned an impressed seaman to the British, and he was hung by the British. And this was a cause célèbre, and there was a motion on the floor of the House to censure John Adams for doing this. And Marshall got onto the floor and gave this lengthy speech where he defended the president's prerogatives. And in the course of defending the president's prerogatives, he used this phrase about the president being the sole organ of the United States in foreign policy. And so, the John Robbins affair, the Thomas Nash, he had two names. That affair is, probably not on the top of everybody's list of things they were thinking about tonight. But so at one level, that affair has kind of gone into sort of the recesses, but that the language that Marshall used in defending the president's prerogative was picked up by the Supreme Court in a case in the 30s called Curtis Wright. And then that case continues to pop up, sometimes attributed only to the court's decision, sometimes attributed to Marshall. But that continues to sort of pop up every time there's an important separation of powers issue in the Supreme Court that involves the president's prerogatives in foreign affairs. And Don argued a case while he was Solicitor General called Zivotofsky about the president's authority to essentially recognize foreign governments, and it manifested itself in a dispute over the passports. And the court kind of wrestled with this issue, wrestled with the sort of sole organ reference, and essentially ruled in favor of the government in Don's position, but sort of cautioned people against overreading sort of that phrase. And I mean, that phrase wouldn't be what we're talking about today if John Marshall weren't John Marshall. If John Marshall, with all due respect to the people of Richmond, had just been a representative of Richmond, not gone on to be the great Chief Justice, not gone on to be this iconic figure in the law, probably that speech kind of falls into sort of, the dustbin of history. But because it's Marshall, and so I'll stop talking and let my colleagues get in a word in edgewise, but I'll just say, that's just an anecdote that I love that just shows that, if you're briefing a case in the Supreme Court these days, if you can trace something back to John Marshall, I mean, you do it. And I mean, you go out of your way to do it, and it has force. I mean, every one of the justices, I think, has just the greatest reverence for John Marshall and the Chief Justice, the great Chief Justice. If you can, even if you got to find his House of Representatives speech, if you can loop it back to Marshall, you're halfway home.
And conversely, if your opening line is Chief Justice Marshall was wrong, you're probably on the losing side of that case.
You're not going to lose the right way. Yeah.
But I mean, I think that Marshall's legacy is really in the entire structure of what we do. The sort of high watermark of the Federalist Party was the ratification of the Constitution, and John Marshall was one of the leaders of the ratification of the Constitution. After that, you pretty much saw the Federalist Party wane and the Republican Party at the time move into ascendance with Thomas Jefferson. And at that point, Marshall's job as the Chief Justice was to essentially defend the high watermark of the Federalist Party, which was the enactment of the Constitution And one of the great things that you saw was that even as Republican presidents put more and more members onto the Supreme Court, where Marshall saw his Federalist majority disappear, he was able to convince all of those successive justices from a different political party who had a very different view of the role of the states versus the federal government to adhere to his viewpoint on what the original Constitution meant and the federal system that it created. Not to keep harping back to our old boss, Justice Scalia, but years ago I had an opportunity to attend a Law Day speech that he gave at the Marine Corps at Quantico. And it was a speech that I'd heard him give before, and he talked about how if you ask a lot of people what the important parts are about the Constitution, they go straight to the Bill of Rights. And Justice Scalia's response was, every banana republic has a Bill of Rights. Most of them are better than ours. They're more detailed. They have many more provisions. But that's not what makes our Constitution so important and so durable. It's rather the structural parts of the Constitution. That's the part of the Constitution that was essentially the triumph of the Federalist Party. Initially, it was the Republicans that were trying to impose amendments on the Constitution right away because they wanted to prove that the original Constitution was so fatally flawed that it had to be amended at the outset. And it was the Federalists and John Marshall who led the fight against those original amendments. They came later, but those original amendments as part of the original Constitution. And it's those structural protections, the separation of powers between the three branches and the federal system, the separation between the federal government and the states, that ultimately folks like Marshall believed would be the bulwark of freedom. And that's, I think, the legacy that we live with. So many of the cases that we fight about are what are those separations, but horizontally between the branches and vertically between the federal government and the states.
Yeah, and one other thing that we take for granted, but was John Marshall's achievement, was the very idea, picking up on what Paul and Noel referred to, that when the Supreme Court rules on a matter of what the Constitution means and says to another branch of the federal government or says to a state, what you have done violates the Constitution, that actually would be the last word, and that would decide the matter for the country. That was, far from a foregone conclusion. That was a hotly debated political and jurisprudential issue through decades and decades, and through the ways that Paul and Noel identified, and then also I think through, I don't know whether it's the force of his personality, the force of his intellect, or both, but unlike now, now when a big case comes out, you read in the paper, well, Justice X wrote the majority opinion and Justice Y concurred, and there were 3 or 4 dissents. And in Marshall's time, he managed, in a departure from the tradition in England at the time, to get the court to speak with one voice in almost every decision. So that even where individual justices might have had a different view about what the right outcome was, the opinion spoke for the court and almost always spoke unanimously. And that was really vitally important in this contest to establish that the court actually was going to play this role in our system of having the last word on the Constitution. That fact that they were able to speak with one voice as often as they did was really important contribution to that. And that I do think is a very important part of Marshall's legacy also.
And actually, prior to Marshall, I think that each justice would just write their own opinion.
Yeah.
And you kind of had to read them and figure out where each one came out to find out who won.
Yeah, let's talk about that a little bit. That's a significant shift, to speak with one voice as an institution. And I think it might lend itself to something we hear in the news a lot, which is the idea of legitimacy, the court's legitimacy. What would that word have meant to John Marshall? Would it have been important to him? What does that mean to someone, a student of Marshall's?
I mean, I don't think that at the time legitimacy went to so much, was it what did they have, 7 justices at the time, 6 justices, whether it was 4-2 or 5-3. They were fighting a much more fundamental battle about legitimacy. At the time, it wasn't clear, as Don said, that the Supreme Court had the authority to declare, at least in a particular case or controversy, that an act of Congress was unconstitutional. It wasn't clear that the Supreme Court had the authority to review a final decision out of a state Supreme Court. It wasn't clear whether the Supreme Court had the authority to pass on the constitutionality of an act of the president. Every one of those principles was established in an opinion written by Chief Justice John Marshall. So they were talking about legitimacy in a much more fundamental sense that was, essential to the nation that we live in today.
Yeah, and of course, President Jefferson was howling mad about all of this. I mean, he was constantly complaining about it and trying to get Congress to enact legislation to strip the court's authority, its jurisdiction, and so it was an extraordinarily intense conflict.
And the brilliance of Marshall is, as he's trying to establish the legitimacy of the court and the institution of judicial review, he picks the Marbury case, and the statute that he strikes down as unconstitutional is a statute that purported to give additional authority to the Supreme Court, a mandamus statute, part of the Judiciary Act. And so the brilliance of picking that case to establish judicial review is there's nothing the other branches can do about it or even really defy his will. If he had picked instead a act of Congress that purported to give the president some great authority and then issued a judicial opinion that said, well, the president can't have that authority under our Constitution, then the question of how are you going to enforce that, John Marshall, would have been, because the Supreme Court doesn't have an army, as the saying goes. So he picked the one context where nobody could essentially kind of do anything once he said that the Supreme Court doesn't have the authority to exercise the kind of mandamus jurisdiction that the Congress purported to give them in the Judiciary Act of 1789. So the fact that he picked something where he was denying the court power was brilliant. And it just shows how he was playing the long game to essentially establish a power of judicial review that would eventually be deployed in more controversial circumstances. And then just, Ali, on the point about the majority of opinions, it seems like a subtle point, right? The kind of tradition in England and for the first 10 years of the Supreme Court is these what they call the seriatim opinions. And then Marshall says, no, we're going to have an opinion of the court. And if you just think about sort of the difference, if you're a lawyer trying to argue a case in the lower courts and you're trying to get the lower courts to do something that's inconsistent with what the Supreme Court said, how much easier is it if you can say, well, there's no Supreme Court opinion, so, and Justice Curtis said this, and Justice Iredell said this, and they don't map up, and so do what you want, Judge. Whereas when there's a majority opinion for the court, that kind of essentially boxes in at least the lower courts to have to follow that opinion. So part of what he was doing is establishing the legitimacy of the Supreme Court vis-a-vis the other branches, but at the same time, he's establishing the Supreme Court as the pinnacle of a federal judicial system. And he does all of that and gets his colleagues to go along. There's just personal brilliance. I understand it took a lot of Madeira served to his fellow justices. That also helped. But it's just what a remarkable legacy.
Yeah. It's like for the court across time. So when they don't say, they say we decided, even when it wasn't that court, those 9 people, which is interesting. So let's talk about Madeira for a second. So one of my favorite legacies of Marshall is he believed in breaking bread with colleagues and the importance of collegiality. And I'd be remiss if I didn't point out we have former Solicitor Generals from different presidential administrations, all who like each other. And I guess I want to know, do you think that is alive and well at the court in the office of the Solicitor General? And do you think it's important? I know you do. So tell us why it's important.
Yeah, it's really important. And one thing about the tradition of the office is that every SG takes extremely seriously and feels a deep obligation to sustain and protect, is that it's a nonpartisan institution. It's going back to some of the stuff Paul said earlier about the relationship with the office with the court. That important part of that is that it not be seen as a partisan institution. So it was, I think, important to all of us in thinking about, there's 20 some odd lawyers in the office, and every SG is going to hire some number of younger lawyers to come in as assistants, to really do that hiring on a nonpartisan basis so that the office doesn't appear to be tilted in one political direction or another, and to try now, and now this can be challenging, of course, because you're arguing cases in front of the court on behalf of an administration. That administration is going to take policy positions that are going to seem very political, and the SG is going to be defending them, so there's going to be some measure of that. But trying to create a sense of confidence in the court and in the public, as well as in the rest of the executive branch, that this is not a partisan operation, is a really important part of the job. And I think it then is part of the reason why we all come out of that experience and feel like we share a sense of values about it.
And I mean, we really do like each other. Don and I are co-counsel in several cases now, and there are a few lawyers in DC that I enjoy working with more than Don. I think that the civility that you're putting your finger on is essential. We're in a day and age, you don't have to look far to see how corrosive our political culture has become and how vitriolic the exchanges have become, whether it's driven by the political world or whether it's driven by TV news. I have no idea. But one thing that to me has always been essentially important about the legal profession is that we need to be a model of civility. We need to exhibit how people ought to be talking about these very difficult issues, because every one of us has had to argue the most controversial issues of the day when we were in the job of Solicitor General. And the only way to effectively resolve those kinds of very difficult issues is if you have people up there very civilly presenting the best arguments that can be made on their own side's behalf, so that the justices also acting as a civil and collegial body can come to the best decision. If we're just taking pot shots at each other and trying to posture for the news cameras, we're not doing the administration that we're representing any favors, and we're certainly not doing the justices any favors, because they're not able to try to figure out what the right answer is to these most difficult issues.
No, I mean, I agree with that. And, the reason, the Madera went a long way in Marshall's day is because, they were dealing with these kind of, difficult issues, but, the level of the issues, I think, have only gotten sort of more momentous. If you think about just, last term in the Supreme Court and some of the issues that the court was dealing with, and, the decision whether to overrule one of its precedents, Roe v. Wade, I mean, that puts so much pressure on the institution and on sort of, the individual justices. And I do think that, all of the justices sort of value the, values of collegiality. There are institutions that the court has, they have lunch after argument. They don't talk about the case. I hear they talk sometimes about the advocates, but but they don't talk about the merits of the case. And I think those kind of practices, are absolutely vital, especially when you consider how controversial the issues that they're dealing with. And just to underscore, a point Don made, I do think, that's an important thing for the justices. But I do think that, in the SG's office in particular, that is also something that really, really is valued. And when I was Solicitor General, not only did we try to hire on a nonpartisan basis, but like, if anything, I almost had a bias to kind of try to hire people who had clerked for some of the more liberal justices, because I figured I already knew how Justice Scalia thought. Like, I didn't really need that much help on that. But like, one of the things that we all do, both in the office and subsequently to prepare for Supreme Court arguments, is to have moot courts, where people in your moot court, ask you questions along the lines that the justices would ask. And if you sort of think about that, if you sort of just, as the SG, would hire and just have people that think like half the court, you're going to have really lousy moot courts, because you're not going to get asked half the hard questions. And so, I was, very important to me, and I think this is just a tradition of the office, to sort of hire people sort of across the spectrum to make sure it's good for the office, but it's good in the short run too. You just get better moot courts that way. So it's and I do think that does really pay dividends in lots of sort of small but important ways in terms of just kind of the way the office approaches issues. Because even if it's a very politically controversial case, there's a thread of the long-term interest of the federal government in the issue. And, and it really cuts across administrations, right? Because a Republican administration might kind of like property rights a little bit more than a Democratic administration. But at the end of the day, the government is a taker of property, not a takee of property. And so, you kind of have to keep that in mind as you're considering what the government's position is in a particular case. And, it's so too in other areas of the law. So I think, really putting a premium on that makes the office function at a higher level than it otherwise possibly could.
Yeah, and Al, if you just permit me one more. Another part of it too is that, Noel mentioned that he and I had that case against each other. Paul and I have had a number of cases against each other. And there were, cases of really great importance. And to actually, for me, and I suspect we all share this, you come out of that process sort of with a sense of awe, that these people that are on the other side of you in these cases are extraordinary lawyers. And then, it's kind of, sort of an intimate process being in the court and arguing. And, I also came away from it with a sense of, not only about the brilliance of these two folks here as lawyers, but of their good faith and that their commitment to sort of the same shared sense of values that, we live in a constitutional system. We make that a matter of paramount importance. We are all each in our own way dedicated to the preservation of that system. And so that just generates an enormous reservoir of respect.
What's amazing to me is you hear that same refrain year after year from alumni of the Office of the Solicitor General, regardless of which presidential administration they were serving. And how do you reinforce those norms? Like, what makes that office unique? How is it handed down from one generation to the next?
This guy named Ed Needler.
I wonder.
This guy named Ed Needler. He's the senior deputy Solicitor General in the office. He's been there for how many? 45 years now? 40 years? And he is, at least you guys might have different views, but to me, this guy, Ed Needler, he transmits the culture from one generation of assistants to another. And the fact that within that office, you have, the way the office is structured, you've got the Solicitor General, you've got 5 career deputies, and then you've got about 16 assistants to the Solicitor General. That's the structure of the office. The career deputies tend to be there for a long time. Folks like us, we float in for a few years, the administrations change, but these are people who dedicate their entire careers to serving in that office. And that's one way that I think the culture of the office is transmitted, but it's also just being part of a larger legal culture and maybe being to a certain extent a leader within that legal culture. I think every one of us feels the obligation to transmit those types of values.
Yeah. Also, the younger lawyers in the office really believe it, and so if you were to come in as an SG and conduct yourself in an overtly political manner or seem like you were using the office to advance partisan objectives, you'd have a full-scale revolt among your staff. You wouldn't be able to manage it. It wouldn't work because those values really are ingrained.
Did anything surprise you when you started in the role of Solicitor General? Anything you weren't expecting?
I mean, I'm the wrong person to ask because by the time I was Solicitor General, I'd been in the office for 4 years. I think what surprised me most, though, about coming into the office when I first came into the office really was this notion that what really differentiated it from being a lawyer in private practice was how much additional knowledge you were charged with when you went up to the podium. Because, it's like the corollary to kind of losing the right way or winning in the right way is like, you are expected by the justices to really understand all of the various far-flung interests of the U.S. government. And so, when you're arguing in a private practice, like they don't ask you about some other aspect of the corporation that you don't know anything about. Like they stick to your, the siloed information. But when you're up there in the United States, like if you're arguing a case about the Environmental Protection Agency and there's some shared statutory authority with the Army Corps of Engineers, the fact that the case involves the EPA rather than the Army Corps or vice versa is not going to stop the justices from asking you, all sorts of questions about that. I mean, sometimes, they will, essentially, I mean, I think, Don, we argued a case where you got asked by one of the justices, is that the State Department's position?
Yeah, right.
I mean,
Yeah.
you get asked, like you are expected to know kind of all of this. And in some ways it's incredibly daunting, but in some ways, one of the really glories of the office is when you get a new case, you sort of, call in the expertise across the entire sort of federal government and you bring it into one room and you get the benefit of all of those kind of different sort of, agencies and their expertise. I had this one anecdote, I think we're not in the war story part of this yet, but I had one anecdote where, I was arguing a case about the sort of jurisdictional reach of the Clean Water Act. And Justice Scalia was all over me about, sort of, the ridiculous position of the United States that, even a ditch is covered. And, I was able to tell him only because a guy in the Army Corps of Engineers named Lance Wood told me this in a moot court. But I was able to tell Justice Scalia, well, actually, technically, Justice Scalia, the Erie Canal is a ditch. And I think we all think that's part of the navigable waterways of the United States, right? And it's not easy to get Justice Scalia to take a step back, but he did. But that's like, I didn't come up with that answer on my own. I came up with that answer because, in the SG's office, you have the benefit of all these, these government lawyers and to Noel's point, the kind of the ethos of the office, like Ed Needler's like the perfect embodiment of it. But there's an Ed Needler in almost every government agency. And they also are these repositories of kind of the institutional knowledge of these, various agencies. And in the SG's office, that's really what you want to tap into, because you want to win your case, but you really want to make sure that you are kind of vindicating the long-term interests. There's, things change from a Democratic administration to a Republican administration, but there's like this kind of core of institutional interest that stays the same, and that's what you really want to protect in the office, and that does, I think, kind of permeate the whole enterprise.
I want to make sure we save time for questions, but I also want to make sure we get to the war stories part. So, would you like to share, I guess, one of your favorite moments, either in the court or as SG, one of your favorite moments, or an embarrassing moment, or whatever you want to share with us? Stars, they're just like us.
Yeah, so I have plenty of embarrassing moments. My favorite moment also involved Justice Scalia, and it was sort of an analogous to the anecdote Paul just told, because it was like, he got the best of me almost every exchange we had for my 5 years as SG. But there was one time when I got the best of him, and I did it by using a joke, which is something that, you're always cautioned not to do in the court, and I never do except this one time. And I actually wasn't spontaneous, it was a planned joke. I tried it out in all the moot courts, and everyone said, don't do it, don't do it. I did it anyway. It was in a case called King against Burwell, which was about the Affordable Care Act, and was about a particular, not about the constitutionality of it, but an interpretation of a statutory provision that, had it been interpreted one way, would have led to the law really not being able to function anymore. And the most natural reading of the words in the statute probably were not so good for the government. And so the argument that we were making was, well, geez, if you read it that way, the whole thing's going to come crashing down. It's going to be a disaster, and Congress can't possibly have intended that. And we knew that Justice, there's an answer to that line of argument, and we knew Justice Scalia, it was easy to anticipate that he was going to push forward the alternative point of view, which is, well, if that's a problem, Congress will step in and fix it. And so knowing that that was going to come, or anticipating it, I had decided that when it came, I was going to do the following. I was going to shrug my shoulders and go, well, this Congress? Because we were at a time of divided and dysfunctional Congress, as we often are. And it actually worked, everyone in the courtroom except Justice Scalia laughed, and he kind of backed off. He was back at me again in about 2 minutes, but that was probably my favorite moment at the lectern in 5 years.
My favorite moment really didn't have a whole lot to do with doing the job directly, but it's those things that happen. You're in the job and you can kind of get a little bit full of yourself. You think, oh, I'm the Solicitor General, but every once in a while something happens that kind of reminds you that you're just another guy, right? And so one of the things I like to do as SG was I would sit out in the corner of 10th and Pennsylvania Avenue with a pile of briefs and a couple of cigars, and that's how I would do my work. In the summer, when it got particularly hot, I'd walk a block down to right in front of the Trump Hotel. There was a big tree that cast a lot of shade, so you could sit in that tree and have your cigar and not be as hot because you had some shade. So one day I was sitting out there with a cigar in my briefs and I needed to use the restroom. So I set my cigar down. I walked into the Trump Hotel and I came back out and there was this homeless man sitting there smoking my cigar. And as I walked out, he just looked at me and grinned. And I said, enjoy the cigar. I went back into the office and finished the day.
I don't really want to follow
Yeah,
that.
I understand.
So let me just tell one war story. It's not particularly funny, and it's not about oral argument. And it's actually, there's a lesson there too, which is, arguing on behalf of the United States and the Supreme Court of the United States is the greatest thrill about being the Solicitor General or in the office of the Solicitor General. And it's a focal point of a lot of what we do. But for every 30 minutes at the podium, there are thousands of pages of briefs that are written, including in the cert process and cases that never get to argument. And all of that briefing is very important. And when I was in the office as a deputy, actually, there was a challenge to the McCain-Feingold, or Bipartisan Campaign Reform Act. And there was a special provision in the law that created a direct review mechanism to go right from a 3-judge district court to the Supreme Court of the United States. And so these proceedings took place after the law passed. There were like 11 different challenges to the law that were consolidated in a single case. The 3-judge court produced a 1,000-page opinion with 4 different opinions for 3 judges, just showing kind of how divisive and kind of messy this was. There were 11 different petitions for review filed from that decision to the Supreme Court, and they were all supposed to be consolidated through in a single case. And we were defending the constitutionality of the statute. And by rule, we could have filed 11 different 50-page briefs. We could have filed a motion for a 500-page brief. That sounds absurd, but the Justice Department had filed, multi-hundred-page briefs in the lower court, and the Federal Election Commission was separately represented in the lower court, and they filed 100-page briefs. And we filed a motion with the court for permission to file a single 140-page brief, which is still the longest brief I've ever had my name on. But we, the reason I use it as kind of a war story is I think it's one of my kind of proudest times in the SG's office, because I think we took a case that was very unmanageable for the court and we made it manageable for them. We made it look more like a normal case to them. And it kind of captures the responsibility that the office, I think, feels to the Supreme Court. We're arguing in front of them. We want to win. Sometimes we lose and we don't think we lost in the best possible way. And we, curse deaf heaven with our bootless cries. But sometimes, we really do sort of feel like, our job is to make the justices' jobs easier. And that sort of case really embodied that. The other part of the case I really liked is that was a statute that I think your average Republican didn't think much of. And the Republican Solicitor General's office and the Republican administration was defending the constitutionality of the law. And that's another kind of tradition of the Justice Department and the Solicitor General's office in particular that sort of builds in some of the nonpartisanship that Don was talking about, which is, although there are exceptions, over time, for the most part, the office will defend the constitutionality of acts of Congress, whether or not we think they were the best thing since sliced bread from a policy matter, but we'll make good faith arguments in defense of the statute. And that was context here where you really saw that, because you had the Republican administration defending what was probably at the time the single most important Democratic legislative initiative. So I thought that anecdote really captured a lot about the office.
And so now it's time for you to ask your questions. Now I understand we have some roving microphones. Is that the right? So if you, okay, here's one. This is sort of
on either side.
Okay. Oh, great. Okay, terrific. So if y'all find a willing participant, okay. Why don't you ask your first question?
First off, thank you for being here, and thank you, Don, for your comments about keeping politics out of it. But the media, and therefore the public, always labels judges. Frequently, they say they're liberal or they're conservative or progressive. Others like the term, well, he supports the Constitution as a living document. Others say, well, that another judge is an originalist or a textualist. I'd like to hear any and all of your comments about labels.
The danger of labels, I guess.
You want to start? Yeah, sure. I'm happy to start. I think what's actually the actual truth of the matter, I think, is that different justices have different judicial philosophies. And that's always been true on our Supreme Court. And it will probably always be true. And I think what's important is that they hold them genuinely. I don't think any justice says, well, I am going to adopt this approach to thinking about law because it will consistently generate the political results that I want. I just don't think that. I don't think any justice really is operating at that level. I might agree with, I might be more in tune with the judicial philosophy of some than others, but it's something that they all bring to the process, I think, in good faith. And frankly, probably, I think at least a healthy thing for the system over time to have those different perspectives on the court, because the presence of the different perspectives and the articulation of it and the interaction of them, they tend to keep each other honest, and because, no way of thinking about law or thinking about the Constitution is, free of its shortcomings. And so I think having that kind of interaction, at least from my perspective, is a good thing. But my view of all that is that it's operating at a level of good faith, essentially.
Yeah, I certainly agree. I would say, though, there is this sort of tendency, for example, to refer to justices by the political party of the president who appointed them and all of that. And in an era when a John Paul Stevens or a Justice Souter, for whom you clerked, were Republican appointees, it was a lot easier to try as a lawyer who believes, everything Don said. But to me, it was a lot easier to explain that there's not a one-to-one correspondence here when you had sort of justices like that. And if I do sort of have a concern, it's, and I'm in Richmond, so I'll play to the home crowd a little bit, but Lewis Powell, was a justice who had a perspective that was different from some of the other justices at that time, and I think different from almost any justice on the court right now. And that was born out of the fact that he had been in practice almost his whole career. And it's pretty hard to imagine a president of either party appointing a Lewis Powell at this day and age, if for no other reason that I don't know his exact age, but Lewis Powell's on the older side when he was appointed. And, that used to be a good thing in a judge or, a justice. And now I think it's all but disqualifying across partisan lines.
Yeah.
And so, at the one hand, I agree with everything Don said, but I also think there are a couple of sort of, modern tendencies that do take us in a direction that, in my humble view, is not entirely healthy.
Another question.
I heard they put out quill pens for you guys. Do they still do that? And what do you do with those things?
Oh, wait, I'm sorry.
They put out quills. Yeah, when you argue a case, they put out
Oh,
quills.
quill?
Yeah.
Yeah, not everything's changed since John
Yeah.
Marshall.
I didn't know. They put Madeira out too.
Oh, I wish.
One of you worked for a president who was a lawyer. The other of you worked for presidents who, forgive me, may not have even heard of John Marshall. Humor aside, or attempted humor aside, what was it like to work for a president who, at least on paper, understood the process of the law?
So I guess that's directed to
Yeah,
me. It's interesting. One of the things when we talked about the nature of the office, part of preserving its reputation for being straight shooters and being nonpartisan is actually to maintain a pretty significant degree of separation between the Solicitor General and the White House. It's not complete by any means, but the idea is the Solicitor General is supposed to figure out independently what the right course of action is for the United States. And, during my 5 years, I think I don't know, maybe I had 2 conversations with President Obama about legal subjects, and they were situations in which he actually had a decision to make, and so there was no getting around talking to him. But that was it. Now, I will say in those conversations, it was a little bit intimidating because the guy could pull, because he was not just a lawyer, but he had been a law professor. He could pull constitutional cases out of the recess of his mind. It was quite amazing. It's sort of, I suppose, surprising to those of you who aren't sort of inside the process. But I just didn't have very much interaction with them. Some, but not a whole lot.
And that's by design.
Yeah, and
right?
that's by
Yeah.
design, right?
Another question. I'm not sure where the microphone.
Hello. You think they ever will allow cameras in the Supreme Court?
Oh,
And is that a good idea or a bad idea?
what would Justice Souter say?
Yeah, so I'll take that one. The answer is no. They won't, and the reason they won't is because I think it's their decision to make. Now, if Congress ever passes a statute that purports to mandate it, there will be an interesting constitutional question, seriously, about whether that statute is constitutional. For what it's worth, I'd be happy to argue that that statute would not be constitutional, that gets too much into the way that the judiciary operates its own procedures to be consistent with the separation of powers. But I'm sure, a dutiful SG would defend the constitutionality of that statute, and it could go all the way up to the court. And I think there's a rule of necessity which would say they would not recuse themselves. And I guess if I were the lawyer challenging the constitutionality of the statute, I'd like my chances. But even apart from the hypothetical statute, at least until the hypothetical statute, it's the justice's decision to make. It's hard to see from the justice's perspective what's the upside of having the sort of cameras in the court. I will say, and I've already said this publicly, as an advocate, I should probably just be quiet and say nothing about this and say whatever the justices want is the best thing. Personally, though, I actually don't see a particularly good government argument for why there shouldn't be cameras in the court. What they do is just sort of too important for it to be not as accessible as sort of, the Congress, or really as accessible as it sort of could be. And I also am a firm believer that if the court did allow cameras in the court, it would actually be good for the court's public reputation. I think if people saw the way that the justices proceed, how seriously they take the case. I mean, obviously viewership would go up on like the high profile issues, but if a couple of hardy souls sort of stuck around for the second case that seemed like a really boring bankruptcy case, what they would see is that the justices were every bit as well prepared and as engaged in those cases as they are at the, in the higher profile cases. They would see kind of the opposite of a kind of Senate hearing where, you have one justice, one senator presiding and everybody else is gone. Like, you could have, C-SPAN could have a camera that showed all 9 justices and they'd all be there. So there is, to me, there's a lot to be said for the upsides of cameras in the court, but I don't get a vote. And the 9 people who do, I think are unanimous that there shouldn't be cameras in the court.
If you could have a camera that showed the proceedings as they are, then I think I might agree with you. But I worry, and I think probably a lot of the justices worry, that once you introduce the camera, the proceedings are no longer going to be as they are.
Yeah.
They're going to start to move something closer to like what we see in congressional, debates.
Yeah, and that's the concern, and I think it's a real one. But I will say, and it's one that I had shared until I realized, well, that now lots of the federal courts of appeals, a level below the Supreme Court, they actually live stream the video of the arguments, and it's not the Supreme Court, so it's not exactly the same thing. But I've argued a bunch of cases now where there's been live stream video, and it didn't have any. I sort of forgot about it within about 5 seconds of the argument starting, and to me there isn't any noticeable effect, at least at that level. So I wonder actually, I share that concern, in a theoretical way, but I just wonder if that's how it will actually play out if they do it. I don't know. But we'll never know.
Yeah, we'll
so
never know.
It doesn't matter. So.
Well, I think we're at the end of our time together, but I just want to say thank you so much for joining us here this evening. It's been a real treat for all of us. If you please join me in thanking
Thank you. That's well done.